We now call the first case on this morning's docket. That is case number 108599, State of Kansas v. Hudgens.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Caston Hudgens. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Your Honor, I remind the court that this case is an appeal out of Cherokee County stemming from a tragic accident wherein Mr. Hudgens, driving a car, collided and tragically killed Teresa Kemp and her daughter. And so the first two issues in this case sort of arise from, I guess, what I feel like sort of a good fact of the reality of Kansas communities, the small town Kansas communities, is when tragedy happens, communities rally around. And that certainly occurred in this case. And that's a good thing, but it creates complications in criminal cases sometimes. And those complications arise in whether or not a person can get a fair trial in an atmosphere where people have rallied around victims like this, and if you can, in what kind of circumstances. And I think these first two issues are tied to that. The first issue in this case is whether or not the district court should have changed the venue out of Cherokee County and found another location in which to have this trial where the pretrial publicity was not so pervasive. I set the factors out in the brief, and I won't reiterate them here. Obviously, there's a lot of factors that weigh in favor of relocating this trial. I sort of know, though, as an appellate attorney, that there are other cases with very notorious or horrific crimes where the court has said there wasn't an abuse of discretion for failure to change venue. So I wanted to focus on, I think, what is maybe different about this case, and particularly in relation to the second issue, how combined why we think it requires a new trial. One distinction in this case is there was pretrial publicity, but not just pretrial publicity about the facts of the incident, but even judicial commentary, because a civil trial had occurred in this case before the criminal trial. So not only is there sort of just news reporting about the incident, there are news reports and statements by a judge of the district court regarding these circumstances and that judge's opinion of the defendant's defense. So that certainly is different than a lot of cases we see, where it's not just news reporting, but a judicial imprimatur on or belief about the defendant and the defendant's case. So that's certainly something that's different.
Just to clarify, there are different judges, right? Didn't Judge Jack do the civil and Judge Fleming did the criminal?
But I think a well-respected judge in that community.
Yeah, I get your point, but I just wanted to clarify that fact.
So that's certainly a distinction. More importantly, though, I think the reason that we see appellate issues like this not succeed very often is on the theory that one way we can protect a defendant's right to a fair trial, even in some of these atmospheres of pervasive publicity, is through voir dire, through the jury selection process, that we will allow searching questions of potential jurors, and through that process, we hope and have confidence that we will winnow out jurors who cannot be fair. And in fact, that's exactly what the district court in this case opted for. When faced with multiple motions to change venue, the district court said, well, let's wait. First, I'm not even going to authorize an expert in this case. We'll just see how voir dire goes. And it didn't go particularly well, I don't think. Again, I don't do capital work, so I haven't experienced it. But I would say this is certainly one of the most difficult voir dire processes I've seen, with a lot of strikes and with so many jurors knowing about both the facts of the case and previous civil case.
Well, let's talk about that a little bit, because it seems to me I can't quite from the record figure out how many people the court called in the morning of trial. There's 113 questionnaires. There's a reference to 120 121 jurors, and there's a reference somewhere to 125. So let's just say it's 120 and know that that's an approximation. The court said, we're going to give you 42 people in the panel and let you select from there. Now, of those 42, 20 got struck for cause and they moved in another 20. So a total of 62 people. And that left still 60 people approximately that never got asked any questions. And from all of that, you ended up with 42 jurors who were not struck for cause. And then you had peremptory challenges of 28, and you got down to 12 plus 2, and those numbers don't really seem to cry out of any particular difficulty in getting a jury panel picked. And I think particularly what's bothering me is that when I take that gross number and look at it, and then you don't specifically challenge any particular place where a juror was, where there's a defense motion to strike and overruled, you don't challenge any particular ruling in that way. So it's hard for me to see that there is any real problem here. So how would you respond to that, knowing that I'm having that trouble?
Sure. And my response is that this is not, you're right, that this isn't a claim about particular jurors. And in fact, we know that that's an extremely difficult claim to really sustain. This is a claim about the process. One, whether there should have been a change of venue, which doesn't require a showing that actual bias on the part of jurors. It's a process issue. Whether that process leads to the possibility that we had biased jurors. In combination in this case with the fact that, I would disagree with your characterization that it wasn't difficult to get there. It was difficult to get there. There's a very high percentage of jurors who were struck for cause. A number of more jurors who where there was motion to strike for cause that was denied, often after the district court had sua sponte rehabilitated those jurors. And so, I guess I would disagree with your characterization of sort of the ease of that process. And at the end of the day then, especially in conjunction with, if we're going to sort of rely on the jury selection process to protect this right to a fair trial in light of this pervasive publicity, we have to expect that it's going to be extremely searching. And that's the second issue in this case, which is that the judge cut off the voir dire in this case. Apparently very impatient. I read the record and I'm unclear what the judge's rush to judgment in this case was.
And I'm not sure I agree with that, too, so you can wrestle with me on this. I saw several instances in reading the voir dire where a particular juror was talked about, and frankly, I don't think the questioning was particularly focused. But a motion to strike is made. District court overruled it. Defense counsel said, well, may I continue to inquire? The judge lets him do that, asks some more questions, and then reverses the ruling. So that doesn't look to me like a judge that's trying to jam down jurors on the defense counsel. Given the fact that we have to give discretion, a lot of discretion to the trial judge in this process, I'm having a hard time seeing an abuse of discretion.
My response, Your Honor, is particularly, and again, I don't know by themselves if either of these issues is sort of standalone, but together, particularly, yeah, you do have to give discretion to sort of maybe limit voir dire, but I think that discretion must be at its narrowest in a situation and in circumstances like this, where the district court is relying on voir dire for the very purpose of trying to ameliorate the pervasive publicity, where they've said, look, let's just rely on this. And this court over and over has sort of said, let's rely on this jury selection process to do that. At the end of the first day, the judge showed his impatience in this case, and then the start of the second day, after not very long, says, we're going to stop this, or I'm going to take this over. That's where I read from the record that I believe the judge was becoming impatient. and the judge saying, I think these questions are irrelevant, or I don't think these questions have anything to do with anything because I don't think there's any dispute in this case with regard to the facts.
Is a judge not permitted to ever do that?
I think a judge can do that, but has to have a record to show that the defense attorney was making irrelevant kinds of questions of the jurors, and that's just not true.
Isn't there just a tremendous amount of latitude as to how a judge conducts voir dire and what is allowed and what is not? I think of a federal court where the judge asks pretty much all the questions. I know in my experience at district court, we had a lot of variety in how judges handled it. We had a judge that did control the voir dire and asked almost all the questions and permitted a half an hour questioning, even in first-degree murder cases, and just a broad range of what is permitted, even in high-profile cases, isn't there?
I think there could be, but when you talk about in high-profile cases, again, I think if we're going to rely on voir dire as our guard against pretrial publicity, I think then we have to assume, and the judge in this case should have had to assume, we're going to have an unusually maybe detailed and lengthy voir dire process. The problem here is the judge, well, one of many problems in this case, it seems like the judge thought that, well, we had pretrial questionnaires, so that should solve the problem. But I think the reality of trial practice, and as you all know, I'm an appellate lawyer, but I think the reality of trial practice and voir dire practice especially is that that's just a starting place. That's your answer, but I want to know why is that your answer? And also, I want to see a lot of your nonverbal cues as you give that answer. That those are all important things that trial attorneys use in order to guide them with regard to both their challenges for cause and their peremptory challenges.
And so what you're saying is that in this instance, our voir dire was serving two purposes. One, to determine whether the pretrial publicity, which no one denies was there, whether it was prejudicial. And secondly, to qualify a death penalty jury.
Not a death penalty jury, but
a murder, felony murder jury, which defense counsel has to make an informed decision as to the best jurors for his or her client. And so it's a dual purpose is what you're saying. And do you have any information on what's the normal amount of time for voir dire? Because I seem to recall having DUI cases that took longer than this. I mean, this doesn't seem inordinate amount of time, but we don't have anything, you don't have anything to compare it to.
I don't have anything in the record, and I don't have any sort of secondary authorities. I mean, the court can take judicial notice of its own cases and knows in high profile, in death penalty cases, certainly, voir dire can go on for weeks. And so that's the real problem here.
And just to clarify, they had their preliminary proceedings the first day of trial. The state did its questioning, and then the defense had, 2 or 3 hours? Is that
I think
about
that's right.
And then at that point was when the push came. The next morning you have till 10:30. Well,
the next morning they come back and there's more discussion, and at some point the judge says, we're going off, in chambers for a minute, and says, I'm tired of this.
Well, but the deadline was 10:30.
At the end, yeah.
Yeah. Okay.
And so I think you're exactly right, Justice Johnson, that's exactly what the trial attorney is supposed to do in this case. And my point is, this is the hardest kind of case for an attorney to do that in. That's why I think the discretion is the most limited. I see my time is up, Your Honor.
Your last comment, is that your opinion of what our standard of review is for this issue? Whether there's an abuse of discretion by the trial court?
I think the case law says it's an abuse of discretion, but your case law also sort of guides that, what does that mean in different kind of cases? And so I would argue that particularly in a case like this, where jury selection is being used as sort of the protector against pretrial publicity, that it must be the case that discretion is most limited in that case.
So are you asking us to put an asterisk by our standard tests for discretion?
I think it's appropriate, and this court has in other cases said, we recognize that there's discretion, but in some cases that discretion is more limited. I think that would be appropriate for this court to say, if a court is going to deny a change of venue motion in a situation like this where my colleague and I agree there was pervasive publicity, and we're going to rely on jury selection to sort of mitigate that we have to recognize that's going to probably change that jury selection process. I think that would be appropriate, Your Honor.
All right, thank you.
Do you have any cases or any, either in our jurisdiction, where there kind of is this, where you propose that there's kind of a dual function here, two purposes for voir dire that stand for that proposition? And anywhere, I don't think we've recognized that, but anywhere else?
I'm not. The answer to your question is no. I'm not aware of a case. I'm asking you to make that case because it's before you.
Well, in some respects, we have, because we have said in the change of venue that the proof's in the pudding, that the voir dire experience will indicate whether there's any prejudice, or actual prejudice. But it seems to me that in Carr we set up a two-part. We have the Skilling's factors for the pretrial. There's no chance we're going to get veneer that's going to work, and then the actual prejudice is tested by the voir dire, which to me is a legal principle that wasn't really followed here because we hadn't announced it, but there is a distinction between those two that we made anyway in one of our latest cases.
I think that's right. And the answer is, I think you have discussed the value of these things in different ways in different cases. I think, yes, this would be sort of the first case where you would put them together. Maybe it is talked about in Carr. I wouldn't claim to be an expert on that.
I have a few questions. On the issue about the restriction on placing time limits on defense counsel, is there anywhere in the record where the defense counsel made an objection that he needed more time, or that he said the time constraints were going to prejudice the defendant?
I will double check the record while I'm sitting down, but he certainly objected when the judge became impatient on the second morning and indicated, as the judge was saying.
I didn't see that.
I'll double check and see if I can confirm. It's my memory that the judge was saying, I think these questions are irrelevant, and I'm going to cut you off from asking these questions. And defense attorney's response was, I think if you don't allow me to do this searching kind of inquiry, I'm going to be denied a fair trial. I'll see if I can get a record set when I'm sitting down, Your Honor.
Moving to the exclusion of the policy on high-speed pursuit, was the policy put in the record? I didn't see it.
Yeah, I don't believe the policy was ever admitted in the record, although...
And if I look at the proffer that was made, I don't see where there's any reference to a provision in the policy that was violated. What I see is the defense counsel saying, in my opinion, it was violated. And he says, I have the officer's personnel file here, and he didn't have training, but it doesn't, the dots aren't connected anywhere. Is there somewhere where either in your brief or in the proffer where the dots are connected to show what it is we're trying to prove with this policy?
Your Honor, the only thing I know of in the record, and therefore the only thing that I can talk about, is the proffer that we cited that I think you're referring to.
So how does the proffer preserve the issue?
I think the proffer does say what the attorney, I mean, we don't have to have absolute question and answer for it to be a proffer that's sufficient to raise an issue on appeal. It's whether or not this court has sufficient information to determine whether or not, if we're right, was there prejudice.
But I don't see anywhere that counsel tells us what's in the policy. And because of that, what should have happened next?
Yeah, I mean, this is me gleaning from it, and you will determine whether or not it's a proper inference of The defense attorney saying, in order to do these kind of things, there's supposed to be a certain kind of training, and apparently this officer didn't get that training.
Can you tell us what the officer did wrong in relation to the policy?
One of the things the defense attorney noted in the proffer that we have was continuing a chase for so long, that it went on for 11 miles. That's the one thing that he explicitly noted, I think, in the proffer.
But we don't know if that violates the policy because we don't have the policy.
Well, I think you can infer from his statement that it must violate the policy. But you're right, we don't have the policy. You're exactly right about that, Your Honor.
Okay, that's all I have.
Any more questions?
Well, but what you're complaining about is the fact that it wasn't allowed to be raised. That issue, not whether he violated the policy, but that there was no opportunity to pursue that in the trial.
Yeah, yes, although, I mean, I acknowledge that we have to have some evidence that he did violate the policy, and otherwise there's no prejudice.
But that wasn't the reason that it was denied, was it?
The judge denied it because even if he had, the judge would have said it was irrelevant.
Right. The denial was not because the judge determined the policy wasn't violated. It was just that it was not relevant or material.
That's right.
Okay.
Any more questions? Thank you,
Thank you, Your
counsel.
Honor.
May it please the court, my name is Nathan Coleman. I'm the Cherokee County Attorney. I represent the appellee, the state of Kansas.
Before you get started, can you tell me, in your experience, was this extraordinarily long period of time to spend on jury selection?
I think that jury selection, the voir dire process in this case was adequate. I think that
No, that wasn't my question,
It
Counselor.
went-
I'm talking about the time that normally is spent to select a jury in a felony jury trial. In your experience.
was it extraordinarily long?
Right.
I think it was a long voir dire. In my experience, I had a rape case here a few months back, and we picked a jury within the day. This case went 2 days. Defense counsel was given.
Well, now, that wasn't the 10:30 deadline on the second day enforced?
Specifically, trial counsel for the appellant ended his voir dire and passed the jury for cause. The judge did not say, counsel, it's 10:30, you're done. The defense counsel.
But the judge told the defense counsel that we will be done by 10:30 or I'm taking over.
In chambers, after a lengthy
Well,
voir dire process,
That's
the
a
judge
yes or
told-
no question. Did the judge tell defense that the defense would be done at 10:30?
He said 10:30.
Thank you.
So, with respect to the issue of voir dire, and as it's been tied together, the issue of the publicity in this case, and whether or not a change of venue should have been granted. This was not a case of presumed prejudicial bias because of pretrial publicity. This wasn't the case. And Skilling, if you look at that, I think demonstrates that. The United States Supreme Court gives us some guidance on what was. In the case of Rideau, which is cited in Skilling, was a case that they give you the factors. They say that was an exceptional case where we could say it was presumptively prejudicial, where we're not going to get a fair veneer in here to be able to find unbiased jurors. This is not that case.
Well, but part of the reason you can say that is that the court denied defense request for funds to conduct a survey to explore the pervasiveness of any prejudice.
I disagree respectfully, Your Honor, because in many of the cases that not only Skilling discusses, but this court has discussed as well, there have been pre-trial studies done, and those cases have shown a high percentage of the community, a high percentage of those people who the study looked at knew about the case and had been exposed to pretrial publicity. But what the courts have done is allowed voir dire and questionnaires, detailed questionnaires, to look at that and to go ahead and remedy and see if there's a need for a remedy of any bias that shows up whenever the jury comes in to be selected. So even those cases where there has been an expert used to do that study, they've still proceeded on, even when it showed, yes, there's a high percentage, the judges have still decided to proceed on to voir dire before making their ruling, and have used voir dire, like we should, as a tool to discover bias of potential jurors and pick a fair jury. And Justice Bosles, as you pointed out, if you review the record of the voir dire in this case, this is not a particularly difficult voir dire process. As you said, there were 42 out of the 125 that were called. My review of the record looked like 124 showed up. We have 42 brought in for the counsel to choose from, and this is different than even Skilling, which the voir dire process lasted 5 hours total, and the judge led the voir dire process in Skilling. In this case, our judge allowed the attorneys to do the voir dire process. So 42 people are called up. 10 of the 14, there were 2 alternates. 10 of the 14 were included in that original 42 people that came up, that eventually served on the jury. Those people were subjected to questioning throughout the entire voir dire process, not only by the state, but also by the defense. Trial counsel for the appellant had the opportunity to ask every one of those jurors that was ultimately picked to serve on this jury question. And he did not move to strike any of those that ended up on this jury for cause. In fact, he asked them questions and he passes and moves on to other jurors. Now, I also found that there were 20 challenges to strike potential jurors for cause. My review of the record that showed only 4 of those questions, in fact, were struck because they knew the particular victims in this case, or knew something about the facts, and thought that it would be difficult for them to serve on the jury. And those jurors were struck. There were 14, out of those 20 challenges, 14 strikes. The 6 that were denied by the judge were ultimately stricken through peremptory challenge. So the process worked. You had unbiased jurors serving and giving the defendant a fair trial in this case. So if we...
I want to get a sense of what happened here. You call your jurors 9 o'clock in the morning, something like that. It takes a while to get gathered and sorted, and then you call you fill the box. How many jurors were first questioned? Do you recall?
You had 42.
42.
42.
And when did the state begin their process? About what time?
Your Honor, I apologize. I don't have the specific time.
How much time did the state take on their?
I think I can help you. It was 2 hours. It started at 9:20. The
Okay.
state started asking questions, and they passed the 42 for cause
For
at
2
about
hours.
11 or so, and then there was a discussion between counsel, and then the judge said, well, let's let him go to lunch early, and that way defense counsel won't have to interrupt his voir dire for lunch, and they brought him back at 1 for the defense.
So the
That's
defense-
the way I read the record.
Defense started in the afternoon at 1 o'clock, and there was some impatience by the court by mid-afternoon. As I read the.
Let's look at the record on that impatience, and I think that's being skewed a bit. the transcript, the record, what that shows is defense counsel is questioning. And then at some point, defense counsel stops. And he's looking at papers as if I were to stop right now for 3 minutes and not say a word. I'm not going to do that, but that would be a long time to stand here and not say a word. The judge says, counsel, we need to move along.
Pick up the pace.
Pick up the pace. Then in chambers, later he addresses counsel and says, when I interrupted you at that point, it had been 3 minutes and the jury's getting restless and they noticed that kind of thing. So I don't think it was an egregious, impatience by the judge. I think it was within his discretion and something that we have to allow a trial judge to do is to control the voir dire and keep things moving.
And on that point, do I understand the record, because it's really not in the record, but it sort of infers it, that during that 3 minutes, the 42 people are waiting, but you've also got a gallery with your other ones that you're going to pick up if you lose some of the 42. So you got about 100 citizens waiting for this process to conclude.
That's correct. Only a few, I think, at that point had been struck for cause. So you have the entire pool still waiting.
And each one of them filled out a questionnaire?
I can't say that everyone did. I think there may have been in the record.
Most filled out a questionnaire?
Most filled out a questionnaire.
And there were how many questions on the questionnaire?
Also, Your Honor,
It was an extensive.
it was an extensive
questionnaire.
Yes,
Okay.
it was.
Okay,
And
just real quick, back to you basically had the afternoon, 1 to 5, that's 4 hours, and then an hour and a half the next morning before defense was done with voir dire. Is that about right? 5.5 hours?
yes, Your Honor.
Okay, thank you.
I think what's important also to point out is that the type of questioning that trial counsel was using wasn't, for the most part, directed toward these potential jurors' exposure to pretrial publicity and how that affected their ability not to be biased in this case. His questioning for a rather long time went on and on about just some more what I would characterize as general beliefs. What are their general beliefs about the presumption of innocence? What are their general beliefs about whether a defendant should have to come up and testify or have to present evidence himself on the burden? Not particular to this defendant, to the appellant, but just generally. And so you see that regularly in voir dire, that people come in with preconceived ideas, and then the process of voir dire educates them. Trial counsel for the defense even says that. I understand we're lawyers and we understand that, and you guys don't, and we educate you. That's part of this process. And what you saw happen is that many of the people that the appellant is arguing were biased in this case. It wasn't because of specific pretrial publicity. It wasn't because of this particular defendant. They just hadn't been educated on the process. And so you see them back off of some of the positions that they stated, some of those general beliefs about the presumption of innocence or the burden of proof. You see them back off of that once they're explained the law. And they say, now that I've been here this morning, or now that we've sat through this process, I understand the law and I will follow the law. And we have to give credit. We have to give credit to jurors taking the oath and saying they will follow the law. And that was done in this case. So I think the questioning, he also focused on relationships with law enforcement. That doesn't go to pretrial publicity and whether it was so pervasive that they were going to be unable to have an unbiased position in the case and hear the evidence fairly. He questioned about their...
Isn't that important in selecting a juror? I mean, if you're defense counsel, that's something you'd like to know when you're going to select a juror, correct?
Absolutely.
And this was the only time he had to inquire about that.
Absolutely. And the trial judge, just like counsel pointed out, has to be able to read those nonverbal cues. And we give great discretion to the trial judge who is sitting there, not on a cold record, but who's sitting in that room and can listen to inflection, sincerity, demeanor, candor, body language, apprehension of duty. Those are all things that we say reviewing courts are properly resistant to second-guessing the trial judge's estimation of a juror's impartiality, for that judge's appraisal is ordinarily influenced by a host of those factors. And that's why we give great deference. That's why it's an abuse of discretion. Now, the trial judge, it's not de novo in this case. The trial judge did not limit a particular question, like I'm not going to let you ask questions to the jurors about law enforcement and whether they lie. Right? He didn't, as a matter of law, say, I'm not letting you ask that kind of question, which might take you into a de novo review of whether he erred as a matter of law in limiting that question. He was within his discretion, this is an abuse of discretion standard, on limiting the length of the voir dire process because, in his discretion, viewed that at that point, defense counsel was asking the same questions. He even, at one point, he asked a potential juror, he asked some questions. He moves away from that juror, comes back a few moments later in the record, asked the same juror the same questions as if he had never spoken with her before. And so I think that repetition is what the judge was sensing and feeling like, we've got to move this along. At this point, you're really not going anywhere.
Can I move you over to the closing argument allegation that you misstated the law of lesser included by saying that the jury had to find not guilty? How would you address that issue?
I would say, well, the review, Justice Johnson, that we have to look at, as you're aware, is that one, was it a misstatement? And if you find that it was a misstatement, then we go through the three factors of deciding whether that was clear error.
Yeah, I understand that. I was just inquiring as to whether you disagree that the statement was not a correct statement of the law.
I think it is. I think it's problematic, but we have to look at the trial, the context of the trial as a whole, in determining whether it was. And I think if you look at the Hurt case, you could say...
Excuse me, counsel, in determining whether it was a misstatement of law, we look at the context of the whole case?
The Naputi case says, reading comments in isolation can frequently be misleading as to the message that the prosecutor was conveying to the jury. Accordingly, we review challenged remarks in their full context, trial record as a whole. So I think that courts have reviewed the
entire
statements.
argument. I mean, I think we look at the entire argument to understand comments and context. That's what you're referencing.
Yes.
Okay, I'm sorry, I misunderstood what you were getting at.
And so I think in this case it's particularly important to take into context the argument that was being made. And specifically in this case, the defense argument in this case was not one of innocence. And this goes to the fourth issue here, or this goes to the issue of whether or not that was a misstatement of law. It also goes to the issue of precluding evidence about the policy coming in.
Counsel, I see you're out of time. What are you asking us to do for you?
I'm asking you to affirm the trial court's decisions in this case, Your Honor.
All right. Do we have any more questions?
I do, because I never heard the answer, I don't think, to my colleague's question. So you're saying that there were no misstatements of law in the closing argument?
I think that if you look at the Hurt case and the Scott Herring case, I think you could say it's disputable whether or not he was arguing for, whether he was saying
That you have to agree not guilty before you move to lessers.
unanimous acquittal.
Okay.
And I think that's where I was going on the context. I think the context plays into
They're
making a
ambiguous, and they're ambiguous rather than error, is what you're saying?
Yes, Your Honor.
Okay, thank you.
Any more questions? Thank you, counsel.
Justice Files. I just wanted to try to respond to your question. I'm reading from volume 16, and this is it's cited in the brief. It's just this is where I'm coming from. That this is the second morning around page 39, where the judge says we're going to take a break, and the judge says, "I don't see that we're making any process. The purpose in agreeing to this questionnaire is that you have all this information. Why are you reviewing all this stuff about police officers, et cetera?" And the judge says, you've done everything. The defense attorney says, "I haven't made inquiries of everyone. I don't know how many I've left. Maybe 15. I'm not sure." And the judge says, "You have till 10:30 and then we're done." So think about that. So that's, and the trial attorney in this place on page 41 explains, look, I'm trying to figure out who I'm going to strike. I'm trying to figure out what their biases are. My colleagues, notes that, well, a lot of these questions had to do with, overall more general impressions. Well, yeah, that's right. Because that's, I think, what trial attorneys do in the voir dire process is okay, you said you have some knowledge of this case, maybe in your questionnaire. Okay, I know that's not enough to strike you, but I need to look at then what's some of your general opinions and how are you answering these questions? Because if I ask somebody a question, do you understand the presumption of innocence? Do you believe in it? And they say, yeah, I do believe in it. That's one answer, right? If I say, do you understand the presumption of innocence and do you believe in it? Yeah. That's a different answer. And that's the question and answer my client never got to ask of several of these prospective jurors. Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Of course, we'll take this matter under advisement.